Hi to everybody and welcome to this webinar on the new Trusts Act 2019, which comes into effect on 30 January 2021. The purpose of our presentation is to provide you all with an understanding of some key aspects of the new Act and to let you know what you need to do now with your trusts. We have three presenters today, all of us from Duncan Cotterill's Wellington office. My name is Hamish Walker. I'm a partner in the firm, and no, I'm not also a somewhat topical National MP. I will talk briefly about why the new Trust Act has come about and touch on some key changes at a high level. We also have Kate Mitchell and Alysha Hinton, both senior associates in our office. Kate will speak about disclosure of information to beneficiaries and also about reviewing your trust to ensure compliance with the new Act. Alysha will discuss whether you still need a trust and in particular, look at the main reasons for having a trust. Why is the new Trusts Act even needed? The purpose of the new Act is to make the law of trusts in New Zealand clearer and more accessible. Current trust law is made up of a mixture of three things. Firstly, the Trustee Act 1956. Secondly, increasingly complex case law. And thirdly, other legal doctrines and principles, which have also advanced a lot over the 64 years since the current Act came into force. Simply put, the 1956 Act is no longer fit for purpose in 2020, and so the new Act aims to modernise the law of trusts in New Zealand. It represents an evolution and not a revolution of trust law. When the new Act comes into effect, it will make a number of key changes to existing trust law, some of which I'm going to touch on lightly now, before handing over to Kate and Alysha for a more in-depth look at some particularly important issues. Disclosure obligations. The new Act includes a positive obligation on trustees in most cases to notify someone that they are a beneficiary of the trust and that they have a right to request further information about the trust. This is a significant change and probably one that many settlors of trusts did not anticipate when settling their trust. Kate will discuss this in more detail shortly. Retaining core documents. The Act requires copies of the Trust's core documents to be kept by the trustees, or at least one of them, which is likely to be the independent professional trustee where there is one. All trustees must keep a copy of the trust deed and all variations made to it. Core documents must be kept for the lifetime of the trust. This means financial statements, for example, will need to be held for longer than the law otherwise requires. This obligation on trustees is likely to result in changes to how professionals hold and manage trust documents on behalf of their trust clients. Trustee duties. Although the law has always imposed duties on trustees, the new Act actually defines both mandatory and default duties. The mandatory duties must be performed by the trustees, and they may not be modified or excluded by the trust deed. The default duties can be modified or excluded by the terms of the trust deed, but otherwise must be performed by the trustee. There are some examples on screen of both. It itself sets out all of the duties very clearly. Trustees will need to consider the terms of their trust deed in light of these new duties, and they'll need to determine whether any variations should be made to the trust deed as a result. Trust duration. The Act extends the maximum duration of a trust from 80 years to 125 years. Trustee liability. There are changes to the ability of trustees to exclude or limit their liability, and there are also changes to the rights of trustees to be indemnified from trust property. This is likely to change how professional trustees manage their trusteeship, and it will require settlors of trusts to engage constructively to ensure that their trust is compliant, and also to ensure that both the professional and non-professional trustees are complying with their duties and their obligations under the new Act. Delegation. There are changes to trustees' ability to delegate their powers and functions. In essence, there are increased circumstances in which powers can be delegated, but restricted timeframes during which the delegation is effective. The Act also contains new provisions governing how trustees may be appointed and removed, and new provisions governing trust variations and resettlements. In terms of the removal of trustees, previously where a trustee had lost capacity or where they refused to engage, the only option available to remove the trustee was to apply to the High Court to obtain a vesting order. This situation occurs more commonly than you might expect, and it is a significant cost to a trust. not to mention the delay to commercial and personal matters in obtaining the court order. The Act provides an effective mechanism for the removal of a trustee. Dispute resolution. The Act contains provision for alternative dispute resolution using mediation or arbitration. This is intended to assist the resolution of trust-related disputes without the need for litigation. I'm now going to hand over to Kate, who will talk primarily about disclosure of information to beneficiaries and also about reviewing your trust.
Great, thanks for that, Hamish. So today I'll be speaking on what is arguably the most contentious part of the Act, and these are the new disclosure obligations, which require trustees to actively consider all the beneficiaries and provide them with certain information regarding the trust. Now this, as Hamish mentioned earlier, is a significant change and one that many settlers of trusts will not have anticipated when they settled their trust. The requirement for disclosure applies to all beneficiaries of that trust over the age of majority, which is 18 years. And where the beneficiaries are minors, this disclosure must still be made to them, but via their parent or guardian. So the Act sets out two concepts around this disclosure, and these are basic trust information and requested trust information. So basic trust information, as it sort of says on the tin, is the basic information relating to the trust. So the presumption is that the trustees will let all the beneficiaries know, firstly, that they are beneficiaries of that trust. They'll provide the beneficiary with the names and the contact details of the trustees, and also update them as and when trustees are removed, appointed or retired. Finally, and importantly, they are also obligated to let those beneficiaries know that they can request further information, including a copy of the trust deed. Now, requested trust information, as you probably expect, is all the other information that is above and beyond that basic trust information. It can be requested by either the beneficiary themselves or their representative, and there is no prescriptive list as to what this additional information could include. So it needs to be reviewed on a case-by-case basis, and it will depend on the sophistication and complexity of the trust, i.e. the more sophisticated and complex the trust is, arguably the more information can be requested by beneficiaries. So trustees need to consider now, when they notify somebody that they're a beneficiary of a trust, how they're going to notify them, and whether to provide any other specific information about the beneficiary at that time. While these obligations are really a reflection of the current law as it stands, trustees need to take careful note of the new obligations under the Act regarding this prescriptive disclosure, as it is going to impose significantly new obligations on trustees when they exercise their duties. Now, the next slide that we turn to here is actually a sample clause I wanted to include just for illustrative purposes. It's a beneficiary clause taken from a trust deed that was drafted in the 90s, relatively indicative of of clauses in trust deeds about that time regarding beneficiaries, and you'll see it's quite broad. So we've got the settlors, their children, their grandchildren. We've also got their brothers and sisters and their nieces and nephews, their parents, and also any wife, husband, widow, widower, or de facto partner of any one of those beneficiaries above. So, you know, quite broad. And when we start turning our minds to the disclosure obligations that we're touching on, you can quickly see the burden that this is going to be placing on trustees if disclosure needs to be made to this volume of beneficiaries. In this current example, when we went through this with the trustees, we were able to identify 64 living individuals who qualified under this clause as beneficiaries of the trust, most of whom the settlor didn't actually realistically expect to receive any sort of benefit from the trust. This brings us to the section 51 and 52 of the Act, which is the presumption, obviously, on disclosure. So to quote from the Act, it's the presumption that trustees must make available to every beneficiary or their representative the basic or requested trust information as set out in the Act. However, and this is quite important, before giving this information, the trustees must consider the factors set out in section 53. Now, section 53 will be coming to shortly, and that sets out a range of factors to be taken into account in deciding if disclosure should be made. If after doing that, the trustees decide, if the trustees reasonably consider, after taking into account those factors, that the information should not be made available to any beneficiary, then the presumption of providing this information does not apply. and the trustees may decide to withhold some of the basic or requested trust information from one or more of the beneficiaries. So what is really refreshing here to see is that the Act contemplates that disclosure will not be appropriate in every circumstance, and so the trustees have to exercise a level of discretion. So what are the factors that can be taken into account by trustees when determining if disclosure is appropriate? Well, first and foremost, what are the beneficiary's likely expectations? So does the beneficiary have a reasonable expectation to benefit from the assets of the trust? And this allows the trustees to consider the degree and the extent of the beneficiary's interest in the trust and the likelihood of them receiving any property in the future. So if we refer back to that clause I touched on with the 64 beneficiaries, obviously children of the settlors are going to have a higher expectation to receive some sort of benefit from the trust than the partner of a nephew of the settlor, who will have a more remote interest. To be considered as the settlor's expectations on disclosure. It's going to be really hard to point in any sort of hard and fast rules around what they wanted on disclosure, because likely it wasn't documented as it wasn't a requirement. But clause 21 of the Act specifically requires trustees to have regard to the context and the objectives of the trust. Therefore, it's really important that, if possible, trustees ascertain the settlor's wishes around disclosure and have these recorded. Confidentiality is obviously crucial when it comes to disclosure of any sort. So trustees will need to turn their mind to whether any of the information that's requested impinges on anyone's personal or any commercial confidentiality issues. For example, if the trust has been making distributions to a beneficiary for personal or medical needs, it won't be appropriate that all of this information is communicated to the other beneficiaries. The circumstance of the beneficiaries is another provision in the Act that can be taken into account by trustees. For example, many settlors actually don't want their 18 or 19-year-old children being informed that they are beneficiaries of a trust and being provided with information around the significance of the assets in that trust, when those beneficiaries may be making key life choices of their own. There is some nervousness out there that the provision of this information may lead, in some cases, to a sense of entitlement from beneficiaries, which a number of settlors are quite keen to mitigate. This brings me on now to the effect of providing the information to the beneficiary. And this is one that I think trustees will need to look at quite closely, because I think it's quite important. The trustees are entitled to determine if the provision of any information may cause disharmony amongst the family or the relationships within that family or between the beneficiaries and the trustees. So where information is so important, that it needs to be disclosed, you could possibly look at redacting anything that may create sort of disharmony within the family. Practicalities around providing this information is going to be quite crucial when we consider that clause earlier about the 64 beneficiaries. Where trusts have a large number of beneficiaries, or where the beneficiaries are unascertainable or you cannot locate them, then obviously the practicality of giving full disclosure to these beneficiaries is going to need to be balanced and considered with the effort it's going to take to provide that disclosure. The trustees can also consider if the requests are reasonable and practical. So for a family trust where possibly only a family home and a batch are the assets of the trust, if the beneficiary is wanting 10 years worth of audited financial accounts, the trustees may determine that that is unreasonable. But also the trustees can look to charge for information if it is going to take some time to collate. The Act does specifically say that trusts need to be administered in a way that avoids unnecessary cost and complexity. What is the nature and the context of the information that's being requested? We all know situations where trusts may have a particular beneficiary who likes to ruffle feathers. So is the information being requested reasonable given that beneficiary's interest in the trust? Or is it more of a fishing expedition? So where there's a very clear and specific request for information, such as I'd like a copy of the trust deed, that's obviously going to be quite persuasive in providing disclosure. But where it's a wide, broad, unspecific request, such as all information on the trust since its inception, then obviously the trustees can take that into account and limit disclosure if they think it's unnecessary. Finally, the Act also allows trustees to reasonably consider anything else that might be relevant to that particular trust, which is helpful given that trusts have been set up for various number of reasons and deal with a range of personalities. So The presumption is still that trustees should make disclosure. Trustees are going to keep wanting to ensure that if they do withhold any information for whatever reason, their reasons for doing so are clearly documented and recorded, because they may be challenged at a later date. Bear in mind too, the Act does provide that if trustees decide to provide no disclosure to any beneficiaries of the trust within 12 months of the Act coming into force, they are going to need to apply to the court for directions. Very clearly there is an indication that the Act anticipates at least some level of disclosure being made to at least some of the beneficiaries once this Act comes into play. So what does that all mean? This is a significant move towards openness and transparency, which trustees won't have seen before. As a result, trustees are going to be under more scrutiny, and trustees who rubber stamp requests of settlors will do so more at their peril. There is a clear need to front foot this disclosure requirement and determine how you want to approach this for your particular trust. As I mentioned earlier, reasons need to be documented and clear. You'll need to consider as trustees the factors I've talked through, which may in favour of limiting disclosure, but keep in mind that the presumption is still that disclosure should be made. Obviously, family beneficiaries, close family beneficiaries like children of the settlors, can have a reasonable expectation to receive copies of the trust deeds, asset liability information, and copies of decisions received by trustees, unless there are overwhelming reasons in those factors that would permit otherwise. So that's quite a bit of information I've just thrown at you. So what's the next steps? Well, first and foremost, be proactive. Review the trust deed. It's probably something that many people don't review regularly, but it will be important to ascertain who all the beneficiaries of the trust are, not just the ones that you consider to be the beneficiaries. Also, as trustees, do you have contact details for all these beneficiaries? Because obviously that's going to be a practical implication of all these changes. Claims by beneficiaries are becoming a key feature of trust litigation, and we expect this to only increase with the new Act coming into play and these disclosure obligations. So it's going to be really key to review the reasons that the trust was established. Memorandum of wishes will be a really good starting point. If these don't exist, as trustees, you're going to want to track down the settlors where possible and get these directions recorded in writing. As I touched on earlier, the trustees are obligated to consider the context, objectives, and permitted purposes under the Act of the trust. So familiarise yourself with the mandatory and default duties under the Act and how these will impact on your trust. Hamish talked through these earlier. There's a number of default duties under the Act which many trustees will want to have varied or excluded from their trusts. And we've found that almost every trust to some extent has varied or excluded these default duties so far. Trustees shouldn't wait for requests to come through. Trustees need to determine the approach they want to take regarding disclosure, which is why we're presenting this to you now 6 months out from the Act coming into force, to determine how they're going to approach these requirements and maintain open flows of information where appropriate. The Act does provide that the information must be provided to beneficiaries at reasonable intervals. As Hamish touched on, the retention of core documents is going to be key, and it's an obligation of all trustees to ensure that the core documents excuse me, are held in a central location. Importantly too, you're going to want to understand the specific parties involved in the trust. The reason, there's a variety of reasons really why trusts are established, and they can be quite wide and complex reasons. So understanding the key personalities and the relationships that are involved are going to be crucial. Also consider your position as a trustee. Are there conflict situations which are likely to arise within that trust between the trustees and beneficiaries? And how confident do you feel addressing this? And finally, which Alysha will touch on shortly, is the trust still relevant in fulfilling its purpose? What we are seeing is clear direction that beneficiaries should be provided with more information, and we are also seeing a new generation of beneficiaries who are going to be becoming increasingly well advised in scrutinising the decisions of trustees more thoroughly. Under the Act, as you can expect, this will only increase. Historically, any beneficiaries who wanted to challenge trustee decisions, they faced real practical hurdles in doing so, partly because record keeping by trustees was inadequate, but also because if a trustee refused to provide information, that beneficiary was required to make a High Court application, which was difficult and costly. The Act is changing this position completely. In the interest of transparency, the disclosure of information to beneficiaries is going to be very important. Beneficiaries who can't obtain information about their rights cannot hold trustees to account, and trustees need to be clear about these new obligations. To do nothing is not going to be an option, unfortunately. Inevitably, this discussion leads to questions around the relevance of trusts, so I'd like to pass you over to Alysha now, who will talk through if you still need a trust.
Now that Hamish and Kate have canvassed the changes that are coming into force on 30th of January 2021, it's a great time to take stock of your trust, review your trust purpose, core documents, beneficiaries and the administrative provisions in your trust deed to ensure your trust still serves the purpose you want and need it to serve. Despite the extra administrative burden the new Act may seem to be imposing, trusts are still very useful mechanisms. In my segment of today's webinar, I will canvass why trusts remain valuable and the core purposes that they serve people. These include creditor protection, flexibility in estate planning, protection of assets for vulnerable family members, a layer of protection against relationship property claims, and potential flexibility in tax planning. Unfortunately, we don't have long enough to go into each point in depth today, but please feel free to submit questions or get in touch with us afterwards if there is anything that we touch on that you would like to discuss in more detail or in relation to your specific circumstances. So, a core purpose of having a trust is to protect against business failure and creditor claims. If you own and operate your own business, there is unfortunately, and recent times have shown us this, that unexpected things can happen that are completely out of your control. So there's unfortunately that risk that you could find yourself in a situation where you're unable to pay your debts. To recoup debts, creditors can lay claim to your personal property. So when assets are held by a trust, they are legally owned by a trust and not by you. It is important to note the difference though between protection and evasion. Trust cannot help you evade creditors. Where a trust has been set up to evade personal liability, a court will very likely find that trust to be invalid. However, in situations where you've been making payments in good faith towards your debts, and you set up your trust and transferred your assets to that trust at a time where you were able and you were paying your debts, but for then unforeseen circumstances you now are unable to pay your debt due to injury, illness, job loss, then those assets that are held in the trust will be protected. Another important consideration is that assets will only be protected if they have been completely given away or gifted to the trust. When you retain assets or the trust still owes you money, as a debt back, then they remain vulnerable to a variety of claims. The protection of assets in a trust will only be fully realised once the gifting of the assets being transferred to the trust is complete. In addition, the 2 and 5 year periods for the avoidance of insolvent transfers and gifts under the Insolvency Act must also have expired. So in summary, for your trust to be an effective protection mechanism from business risk and creditor claims, it is essential that your gifting program is completed. This means you will need to be regularly reviewing and updating the flow of assets into your trust and the balance of shareholder accounts. This needs to be happening while skies are blue and creditors are not looming on the horizon. Another reason that people have trusts, which can be in addition to creditor protection or separate to it, is the use of a trust for succession and estate planning. Distributions under a will are open to Family Protection Act claims, Testamentary Promise Act claims, and relationship property claims. If your will doesn't provide adequately for your spouse or partner, children, grandchildren, or other close family members that you may have been supporting financially in a significant way while you were alive, then they can make a claim against your estate after your death. A claim against your estate may also arise under the Testamentary Promises Act as a result of a promise made to reward someone for their work or services while you were alive. Trusts provide more flexibility than wills. Having your personal assets in a trust rather than leaving them directly to family members in your will allows for more flexibility as trustees can decide when to make payments to the beneficiaries and even whether to make such payments at all. Trusts also mean that you can leave all your assets together rather than giving them to individual family members. This means your estate can stay together for all your family to enjoy for years to come. This has been enhanced under the new Act, given the maximum duration of a trust is extended to 125 years. As already mentioned by Kate and Hamish, your Memorandum of Wishes contains your directions to the trustees as how you want your trust to be managed. Trustees have an obligation to follow the Memorandum of Wishes, and this is an obligation that has been strengthened under the Act. This means that you can put very clear instructions in your Memorandum of Wishes of how you want your trust to operate after your death, and as we've discussed, Memorandum of Wishes are not subject to the disclosure obligations. However, those beneficiary disclosure rules that are coming into effect does influence using the trust for succession planning purposes, and it's become a little bit more delicate as beneficiaries will now be able to see trust deed and trust documentation that may contain those directions in the past that before you didn't presume that they were going to be able to see that. And therefore you may want to begin reviewing those documents to see if any beneficiary may raise a flag to them or cause a claim in the future. So we recommend if you have a trust set up for this purpose, you examine it carefully and you speak to us or your usual Duncan Cotterill advisor to understand how best to structure your trust to achieve your intended estate planning wishes. Trusts are also commonly established to help safeguard the interests of vulnerable family members. A really common example of this is where parents set up a trust for the benefit of a child who has a significant disability and may struggle to work to support themselves. Trusts can manage their financial interests and hold income-generating assets to meet their needs by either making funds available or purchasing assets such as their home for them. Another example is parents or grandparents setting up a trust for a specific purpose, such as their children or grandchildren's education. In a similar vein, trusts often provide a way for family members to control assets if they have concerns that those beneficiaries may have an inability to manage their financial affairs, or they may have substance abuse issues. The trustees of a trust can decide when and how to give those specific family members as discretionary beneficiaries of that trust access to the assets held, but can still provide for their specific financial needs. So moving right along, a trust can also provide a level of protection for your assets in the case of relationship property claims. Under the Property Relationship Act, if you and your partner have been married or have been in a civil union or a de facto relationship for more than 3 years, and shorter timeframes can apply, then it is likely that all or a significant part of your assets will be relationship property. This includes the family home and family chattels, even if one person brings them into the relationship. Under the Relationship Property Act, on separation, you and your partner must equally divide the relationship property between the two of you unless exceptional circumstances apply. A trust can help to protect access you don't want the Relationship Property Act to apply to, but timing is key. The best protection is available where assets are already in a trust before the relationship commenced and a contracting out agreement has been entered into between the parties of the relationship. Particularly if assets are being transferred to a trust while the settlor is in a relationship, it is imperative that a contracting out agreement is entered into. Contracting out agreement just simply contracts out of the provisions of the Relationship Property Act, and it gives certainty to both parties. However, when you look at the statistics, apparently only about 8% of couples actually have a contracting out agreement. So if you have a trust for this purpose and you don't have a contracting out agreement, we strongly recommend you speak to us and to understand the potential exposures to your trust property. Trust can be subject to the following relationship property claims, and unfortunately we don't have time to go into all of these in depth, but please speak to us if you have any specific concerns. So the potential claims that can be made under the Section 44 and Section 44C of the Relationship Property Act, which deals with dispositions of relationship property to a trust to defeat relationship property claims. Section 182 of the Family Proceedings Act, which deals with nuptial settlements, claims that trusts are a sham. There's also been recent case law developments around bundle of rights arguments, and this was discussed in the Clayton and Clayton cases, and there's also constructive trust arguments. This is a constantly developing area of the law, and in fact, the Property Relationship Act was a reform to the Property Relationship Act was proposed by the Law Commission just recently, although it has stalled, and we suspect that it will gain more steam once New Zealand succession law, the review and looking into reforming that is completed, and that is expected at the end of 2021. I mentioned the reform to the Relationship Property Act in particular because one of the recommendations the Law Commission made was to widen the court's power in relation to trusts so that the family court can make orders over trust property where that property was produced, preserved or enhanced by the relationship. Only if this proposal goes through, trust will be less of a protection in relationship property claims. Finally, I just wanted to mention intergenerational relationship property issues. Inheritance is separate property under the Relationship Property Act. So if you leave property to your children, it is not inherently relationship property. However, inheritance can lose the separate property status and therefore become available to your child's spouse or partner if it is intermingled with relationship property or used for the benefit of the relationship. A really common example of this is where your child will use that inheritance to pay for their mortgage, it's on their family home, or to use the inheritance money to maybe pay for some renovations on the home. If that inheritance was in a trust, that then is prevented from losing that separate property status and being subject to a relationship property claim. The trust can make advances to the beneficiaries rather than gifts, so those funds can be treated differently for relationship property purposes. This is a tricky area of the law, which, as mentioned, is constantly changing. So if you have concerns around this, please speak to one of us or your usual Duncan Cotterill advisor around your specific circumstances or the circumstances of your children if this is an area of concern. The last purpose I wanted to touch on today is trusts being used for tax and means testing purposes. In the past, trusts have been used and structured to achieve tax savings and to qualify for means test or subsidies. Trusts can achieve tax savings if income is distributed to beneficiaries who find themselves in a lower tax rate than the flat rate tax to a trust. This is done by splitting the income generated by a trust, where that trust might generate the income from business activities or investments, and they split that income between the trustees as trustees' income or the beneficiaries as beneficiary income. However, we no longer recommend setting up a trust for the sole reason of achieving tax savings due to tax evasion issues. However, tax planning can be a consequential or secondary reason to having a trust, and that's perfectly legitimate. Any tax planning should, of course, be done in consultation with your accountant, and in the past we've worked closely with accountants and other tax specialists to make sure we achieve the best result for you and your needs. It's also important to keep in mind that no one can see into the future. So tax benefits that may apply now may not apply in the future and vice versa. So for example, New Zealand doesn't have inheritance tax or death duty, but who's to say if that isn't brought back into policy. This is something to keep in mind now and when you're thinking about maybe winding up a trust. We don't know what those policy reasons will change. Just simply no one can predict what's going to happen. I mean, we can't even keep up with all the MPs at this stage. This unpredictability can affect the purpose you have for your trust and leads me to the last thing I want to mention, as it often comes up in relation to trusts, and that is the residential care subsidies and by default other means testing for government assistance. Government subsidies are income and asset means tested, which means that if you have income and or assets worth over a certain amount, you will not qualify for the subsidy. Generally, the government only takes into account assets you own and not assets held in a trust. For this reason, in the past, trusts were established with the idea of maximising asset structures to qualify for the subsidy. However, we no longer advise people to have trusts for this purpose alone, as there have been recent developments which have all but removed this benefit in relation to subsidies. Also, when you look at the statistics, most people don't actually end up needing a residential care subsidy. The percentage of people living in aged residential care facilities over the age of 65 is only around 5%. And lengths of stay of people in those care facilities is actually quite short. So when you're thinking about the cost-benefit analysis, forming and administering a trust for this purpose is very costly when the likelihood and the benefit is actually quite low. But as this issue does come up quite a bit, I just want to spend a little bit of time canvassing the issues around residential care subsidies, and then I promise I will be wrapping up very soon. So when applying for a subsidy, the government looks at how and when you transferred your assets into your trust. In the past, assets were sold into a trust at market value, at which point the trustees then owe the settlor a debt equivalent to that value. This debt was then forgiven by a gifting plan, and under the current legislative scheme, the maximum gifting amount is $27,000 by couple in any 12-month period up to 5 years before a residential care subsidy application is made. In the last 5 years before an application is made, the allowable gifting amount is only $6,500 in a 12-month period by a couple. Gifting falling within these thresholds will not be considered in the asset assessment. All gifting in excess of these amounts will be considered by the government as a personal asset. The second stage of the assessment is the income assessment. Again, the government will look to see if you have deprived yourself of any income to qualify for the subsidy. A recent Court of Appeal case has made this second stage a real issue to people with trusts, as the Ministry of Social Development has agreed that where an asset has been progressively gifted into a trust, even those done in line with the gifting thresholds and timeframes I just mentioned, they have considered that that is a deprivation of income, and which meant that the person applying for that subsidy in that case wasn't eligible. If the purpose you set up your trust was to qualify for residential care subsidies, then we recommend you speak to us or your usual Duncan Cotterill advisor about the status of your gifting regime and to look at what assets you have gifted into the trust to make an assessment on whether the trust is still the best mechanism for you to qualify for the subsidy. In some instances, we have found winding up a trust to be the best course of action, and in others, keeping the trust is the best course. So, to wrap everything up, trusts have very important protection purposes and they remain valuable asset structure mechanisms. The purpose for your trust may have changed over time. The reason you set up your trust may be completely different for the reason you might keep your trust now. It's also important to keep in mind that no two situations are the same, and it's important to consider to get the right advice to you and your beneficiary's particular circumstances. To justify the administrative burden that comes with a trust, it is important to understand the purpose of your trust, whether that's creditor protection, flexibility in estate planning, layer of protection against relationship property claims, protection of assets for vulnerable family members, and or flexible tax planning, or plenty of other reasons that are out there. If you can identify a purpose for your trust, then you need to review your trust deed and the documents, your core trust documents, to assess the impact of the Trust Act 2019, and Hamish is going to talk about this more shortly. However, if one of these purposes, or you don't really understand the purpose that you have a trust now, then maybe you should be thinking about whether your trust is still fit for purpose and whether to keep it or not. And Hamish will also touch on this shortly. Just a reminder that if you do have any questions, please feel free to submit them and we will try to come back to them at the end. Now over to Hamish.
Thanks, Alysha. So what do you need to do now? In short, you need to run the proverbial rule over your trust deed and trust arrangements, and then you need to make changes to ensure that they comply with the new Act. The Trust Act comes into effect in January 2021. At Duncan Cotterill, we have one of the largest trust practices in the country, and we are well and truly underway with the review of client trusts and implementing the changes resulting from those reviews. An important first question is whether your trust is still relevant for you and your circumstances. You should review the reasons your trust was established. Is the trust still a good idea, or should you consider winding it up? If you do wind it up, care needs to be taken to ensure this is done properly and that the right professional advisors are involved or consulted in advance. This might include your accountant, especially if there might be tax considerations, and it might also include your financial advisor. You need to ensure that you understand and comply with the new beneficiary disclosure rules. You need to review your trust deed. Changes may need to be made to the trust deed to ensure compliance with the new Act and to otherwise best utilise the new provisions in the Act. Some older trust deeds in particular don't contain the power to change the trust deed, so consideration will need to be given to other options in those cases. You need to ensure the trustees are operating the trust in compliance with the Act, and ideally to a best practice standard. This is something professional trustees will be requiring in order for them to remain as a trustee of the trust. The process we are following at DC involves first contacting our trust clients to ensure they understand the need to review their trust deed and trust. We are currently in the middle of that process. Following the review, we discuss our recommendations with you, and then finally we implement the resulting changes to your trust deed and other arrangements to ensure compliance with the new Act. The process might also involve such things as updating wills or the memorandum of wishes for your trust. Please don't hesitate to get in touch with us if you have any questions about the new Act or the review process, or if you would like to discuss your trust arrangements. Sorry, not sorry, if that sounds like a plug, but in all seriousness, we do genuinely mean that, because we know that a lot of people are uncertain about what the new Act means for them and their own circumstances, and we're more than happy to help demystify that and get you on the right track. That brings us to the end of the presentation part of our session today.
Feel free to contact any one of the presenters here today. I just want to thank you all for your time. Feel free to contact us and have a great day.